A few weeks ago, I posted a video discussing a case of ruse or fake drug checkpoints, where the officers would install signs on the freeway saying drug checkpoint ahead, but when you get there, there is no checkpoint. Instead, the officers were watching which drivers would take the next exit, and then they would pull them over. Now, a lot of you were really interested in the topic. Some of you asked me to discuss checkpoints in general, so this is what we're going to do this week. We're going to discuss how do we get here? Why are the police officers began to use these fake ruse checkpoints? What about the regular drug checkpoint, where you pull somebody over and simply check for drugs? Well, that has been discussed by the Supreme Court in City of Indianapolis versus Edmond. By the way, City of Indianapolis is the hometown of author John Green. If you need a recommendation on another podcast, you might want to listen to Dear Hank and John. This is a podcast by two brothers, really fun listen. But today, we're going to talk about drug checkpoints. The Supreme Court case, City of Indianapolis versus Edmond. And before we go on, I want to thank you for listening and watching the LAWSTACHE channel. My name is Anton Vialtsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. Please hit that subscribe button, share my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and some other items. Thanks for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we're discussing City of Indianapolis versus Edmond. This is a Supreme Court case and it deals with drug checkpoints. Now, between August and November, the City of Indianapolis conducted 6 drug checkpoints. They stopped 1,161 cars, and out of those 1,161, they made 104 arrests. Within those 104 arrests, 55 of those were drug-related, while 49 had nothing to do with drugs. The program ultimately had a quote-unquote 9% hit rate. Now, this is how the drug checkpoint looked like. Motorists were driving on the highway. There was a sign that said drug checkpoint ahead. It also said K9 in use. When the motorists arrived, they would ultimately stop everybody. There were roughly 30 police officers. One of them would ask for driver's license, car registration, and insurance. Some officers would make visual observations from the outside of the vehicle, looking inside, using what's called a plain view doctrine to see if there's anything illegal inside the vehicle. And then one of the officers would walk around with a canine, sniffing the outside of the car. Now, the design of this program was that the motorists would not be stopped longer than 5 minutes. Now, we know that the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search or seizure. Of course, here we have a seizure. We have police officers stopping vehicles. We know that under Terry stops, the Supreme Court has told us that at bare minimum, the officers need to have a reasonable suspicion that you're committing some sort of crime before they can pull you over. Now, when we talk about reasonable suspicion, this is individualized suspicion, meaning particular to that individual. And here, of course, the officers were pulling over everybody. So what about suspicionless checkpoints? So here are the 3 examples that the Supreme Court gives us where they previously upheld a suspicionless seizures of motorists. For example, at a fixed border patrol checkpoint designed to intercept illegal aliens. This is from the case Martinez-Fuentes. And at a sobriety checkpoint aimed at removing drunk drivers from the road. There's the case of Michigan Department of State Police versus SIDS. In addition, in Delaware versus Prowse, we suggested that a similar type of roadblock with the purpose of verifying driver licenses and vehicle registrations would be permissible. So all three of these examples are constitutional, according to the Supreme Court. You may now be asking yourself, what is the difference between the three examples I just provided and this particular drug checkpoint? In all of these examples, we have a seizure of the motorist. So this can be the difference, because I just told you in the first three examples, the Supreme Court said that this was a constitutional seizure, not in violation of the Fourth Amendment. Could it be the fact that here we have a police officer walking a canine around the vehicle, having the dog sniff for narcotics? Well, again, if you've been paying attention to my channel, you remember the case of United States versus Place, a Supreme Court case that deals with canines. I've also mentioned this case briefly in my 5-part series titled Vehicular Searches Without a Warrant, where I go through all the exceptions to the warrant requirement when dealing with a vehicle stop. You might want to check out that series after you finish this video, but for now, here's what the Supreme Court says. It is well established that a vehicle stop at a highway checkpoint effectuates a seizure within the meaning of the Fourth Amendment. The fact that the officers walk a narcotic detection dog around the exterior of each car at the Indianapolis checkpoints does not transform the seizure into a search. Just as in Place, the Supreme Court case I previously mentioned, an exterior sniff of an automobile does not require entry into the car and is not designed to disclose any information other than the presence or the absence of narcotics. Like the dog sniff in Place, a sniff by a dog that simply walks around a car is much less intrusive than a typical search. Rather, what principally distinguishes these checkpoints from those we have previously approved is the primary purpose. So let's talk about the purpose of a drug checkpoint. We begin with the obvious. There's no doubt that trafficking of illegal narcotics creates social harms. But of course, the level of threat usually does not determine the type of techniques that law enforcement are using. We can also try to justify this checkpoint under the highway safety concerns, like we do in DUI checkpoints. But the Supreme Court says there's a huge difference. In a DUI checkpoint, we're dealing with immediate threat. We're trying to get drunk drivers off the road so they don't cause an accident and get the general public and other motorists hurt. And here, we can presume that the individual driving the vehicle will be sober. We're simply trying to find narcotics inside the vehicle. There's no immediate threat to other motorists or to the general public. The court also briefly mentions exigent circumstances. The court says that if there's a dangerous felon on the loose, law enforcement may conduct temporary checkpoints to try to find the individual and stop him. But of course, again, there is some type of exigency involved. And here, there is no exigency. What we're dealing with is what the court calls general crime control. And for that reason, the Supreme Court says that drug checkpoints are illegal and unconstitutional under the Fourth Amendment.
The petitioners concede, and the evidence shows, that the primary purpose of the checkpoints in this case is to interdict illegal narcotic drugs. This purpose is ultimately indistinguishable from the general interest in crime control. As a result, we hold that the Indianapolis drug checkpoint program violates the Fourth Amendment. Although traffic in illegal narcotics creates social harms of the first magnitude, the gravity of the threat alone cannot be dispositive of what means law enforcement officers may use to pursue a given end. Our holding today is limited to checkpoints whose primary purpose is general crime control.
Now, the government tries to save the day and say that there is a secondary purpose behind the checkpoint. Of course, the officers can also stop and send to the secondary an individual they suspect of drinking and driving. But the court says what the government is trying to do is simply use magic words because the court has previously ruled that DUI checkpoints are legal and constitutional. They're saying that in this situation, because this could also be a DUI checkpoint, this is also constitutional. The court does not buy this argument. They say that if they allow it, the government will then always use the magic words and call every checkpoint a DUI checkpoint, even though we all know that's not what they're trying to do. So now you understand that drug checkpoints are illegal and unconstitutional, and you now understand why I discussed United States versus Neff a few weeks ago, which dealt with ruse or fake checkpoints. After law enforcement found out the drug checkpoints were illegal and unconstitutional, they began putting out fake checkpoints, trying to see if that sticks. And if you're interested in fake checkpoints, you might want to go and watch the video. I will link it in the description below. It is United States versus Neff. I hope you enjoyed this video today. Give it a thumbs up. Please subscribe to my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching. See you next Wednesday.